if it's a prenuptial agreement and someone comes in our office and another attorney has drafted it, one of the elements in a prenuptial agreement is that you have full and accurate financial disclosures. So if there are no disclosures at the back of that prenuptial agreement, I'm going to question that, because going forward, that could be subject to litigation.
Yeah, and it may affect the validity of the entire agreement.
Yeah, yeah. So now a layperson would normally not know that.
Right.
They come into us and they're going to rely on our experience to dictate what terms have to be in there and basically make sure that it's in their best interest.
And here's an example of a contract that has far-reaching effect, similar to your website issue, that may be in a $400 job, but it may have a very big effect if you don't own that website. Well, this prenup may affect your financial well-being at the end of a divorce if it's not carefully crafted.
And for as much as most people know to go to Google whatever and look at a website, and there certainly is a lot of information out there, I'm sure that there's not a single site that could possibly go through as many questions and proffer as many possible answers as if someone sits down with you and says, are you aware of this, and if this happens, are you prepared to have that happen? Right. Do you actually spend a lot of time right now finding that businesses are more interested in putting together contracts even for small projects, if not small home renovations, but just small businesses, because they're afraid of what might happen if they don't have some sort of coverage?
Usually with what I do, I often see it at the end of the contract when there's some type of dispute. And our question is, well, was it in writing? And let's look at the contract and let's see if there was some breach. Right. But you do more business than I do.
But most things that are small day-to-day kind of deals, so to speak, we don't see until there's a dispute, as Jackie's saying. Yeah. If it's a larger thing, such as the purchase and sales of the business, I'm selling my business, I want to come in and find out what I should have in this agreement. Many times, not always, many times we'll have a hand in drafting that agreement, which is really important, because if the attorney that's going to represent you if there's a problem has a hand in drafting it, that person will have a better understanding of what the issues are and what's involved and what's in it, as opposed to, here's the agreement, this is what I thought it said, and he didn't do or she didn't do X, Y, and Z, I want to sue. Well, when we look at the agreement, many times it's not clearly drafted that that's what was supposed to happen.
And then you have the parole evidence rule, which says the written word takes precedence over the spoken word. Right. If there's a contract.
That's good to know.
And that's the legal standard.
As you would understand. Yeah. Jackie, you and I think David also mentioned or referred to disputes. Do all contracts have a dispute resolution clause? Explain what that is. Okay.
Yeah, I was actually just thinking about that. A lot of times people don't read that fine print, case in point, credit card agreement. You look at the fine print and there's a term in there about what state governs in terms of choice of law, or what legal process will you follow. And what people don't realize is you might be signing that in Rhode Island, but it might be governed by Delaware law. And if it has to be litigated, it would have to, and sometimes there's an arbitration clause, so you give up your right to sue in state court.
So that's what you're referring to, is these clauses that say before you can sue, if you can sue at all, it's required that the parties submit to arbitration. It may be binding arbitration. Sometimes, I think this would be overreaching, it could say you have to arbitrate or have the dispute resolved in Delaware, and you're in Rhode Island, and you're saying, I've got to go to Delaware to resolve this dispute between my credit card for $80. You know, so there can be a little overreaching in there.
So maybe it was on my cable bill, maybe it was on something that I purchased. If I saw that in a contract, assuming that I read that, what should I do about that? Just say it really doesn't matter, it's an insignificant amount of money and I don't care, or this might really cause me some problems later on and I want to challenge that. What should people do?
Well, I think if it involves a significant amount of money, then you need to negotiate that term.
Right. If it's a big contract for something significant, 100% right, Jackie, you need to have those issues resolved. I get these contracts, you know, everyone does, when they go to renew their cell phones and they have that whole thing that prints out that says as long as you're on. What if there's a term in there? Now, here's one where I don't think you're going to be able to negotiate it, but you want to. And let's say, and I'm not saying it does say this, but let's say it says any disputes will be resolved through alternative dispute resolution somewhere out of the state that you're in. Can you say, no, I won't sign this agreement unless you change that? Because I don't think the person in the store has got the authority to change the terms of that agreement.
And you won't get the phone.
And you won't get the phone.
Yeah. But what's interesting about that is oftentimes when they litigate for non-payment, it's an interesting point, they're going to litigate in the state where you live.
Right, because if they're going to sue you, they have to have jurisdiction over you,
Yeah.
and to have jurisdiction, you have to be there.
But wouldn't it be an interesting defense if you say to the judge, well, here's the choice of law agreement, and it says it has to be pursuant to Delaware law,
Right.
or there's an arbitration clause in here. Maybe we need to go to arbitration.
Right.
I've actually
That
seen
would be
that.
enforceable.
I have actually seen that. People will come in my office with judgments, and before they can go to state court, they have arbitration panel, they get an arbitration judgment, and then they take it to state court.
Right,
A judgment meaning something's already been decided.
It's been
in a court.
decided, yeah,
right.
in arbitration.
What about when someone sees that there's a line about mediation if there is a dispute to be resolved? Is that generally a more palatable and reasonable thing to sign on to?
Well, binding mediation, in other words, you're going to
Versus
sit there
none?
until you resolve the issue. There's no real such thing to me, because mediation means that both parties have to agree. So they can't force that on you. But as a step before you litigate and say you have to try that, I don't have a problem with that.
In a contract, should both parties be able to terminate the relationship?
Well, then you have to, again, look at the terms.
And
It sounds
so-
like a real estate contract.
Yeah.
If I get a mortgage, there's a mortgage contingency clause. If you don't give me a
Right.
commitment letter within a certain amount of time, then we can
Right.
terminate
So
the
that would be
contract.
considered a condition
Yeah.
for the contract being enforceable. So if Jackie applies for a mortgage and doesn't get it, she has the right to get out of that contract. It's a condition that has to be met. The termination of a contract, if there's going to be a reason to terminate that's acceptable to both sides, that should be negotiated in the contract. Otherwise, if one terminates a contract without that language, you've breached the contract, and now you're subject to being sued.
When you are entering into a contract and there are other parties involved, perhaps other service providers, maybe it's another bank that's involved, and this is contingent upon this, is contingent upon that. Not all who are issuing a contract would necessarily include all of those strings of contingencies and what if and if onlys. Does that, when you're in that kind of situation, does that demand that you have a lawyer sit with you and rewrite the terms of that contract so that I'm not stuck, for example, if my sale of this doesn't work or my financing of that doesn't work, or if so-and-so doesn't do this, or such and such a company didn't do this so that I could sell this? If there are those kinds of complexities, does that demand that that everyone has a lawyer to sit and rewrite that so that they're not on the short end of a stick later on?
Well, I think it's advisable. Certainly, if it's a contract for $100, why would you spend, a certain
fee
amount
on
of
the
money
attorney.
yeah.
I guess the question ends up being, at what point do I stop thinking that I am capable of doing this myself and say, I really think I need to have, never mind a second pair of eyes on it, legal eyes on it?
Yeah, it probably is a good idea. We do have some statutes that require lawyers look at it. For instance, prenuptial agreements. A good example in Massachusetts, we have a statute that provides for what terms have to be in a contract, a show business contract for a minor, and that has to be approved by the court.
Right.
So that is somewhat complex, and you don't want to just sit down and say, well, I'm just going to sign this blanket agreement and everything's going to be hunky-dory. Because if it's a minor, generally you don't have capacity.
Right, it raises a whole set of other issues.
But there are exceptions in the statutes that allow for show business contracts, provided that, it's negotiated fairly, it's in the best interest of the child, and then the court approves it.
For a contract to be binding, there has to be the agreement we spoke about earlier. There has to be consideration. Both sides are getting something in the bargain. There has to be capacity, one of which is what Jackie just brought up, is a minor is presumed not to have capacity to enter into a contract. Someone under a guardianship is presumed not to have capacity to enter into a contract, and the contract has to be for something legal. So you raise that whole capacity issue when you have a minor sign a contract, and that's a whole nother bag of, or can of worms, if you will, as to what happens if a minor enters into a contract.
Certainly in preparing for this, I was looking at a list that had 10 things that you'd have to comply with in order to make a contract valid. Maybe an average person would understand some of these things. If someone needed to have a lawyer look at a contract, say it's a prenuptial agreement. What does that cost? Just to have someone eyeball and prepare?
Just to look at it?
Yeah, to review it.
And advise.
And
'cause
advise?
You
Yes.
don't want a lawyer just to look at
No,
it.
it can't-
Obviously, to make a
Right,
comment.
right.
Sorry.
Go ahead.
Yes.
It depends on how many hours is spent. If it's a matter of a couple hours and maybe under $500, I mean, I can advise. If people don't want to take my advice, they're going to go ahead and do whatever they
Right.
want, regardless.
Most situations, a prenup, for example,
Yeah.
are going to require advice,
That's right.
negotiation,
That's right.
and redrafting.
Yeah.
So it's probably going to be something more than that. If it's really someone who literally says, I just want you to come in and explain this to me, that is probably more what Jackie was talking about.
If someone wants to have a prenuptial agreement and a lawyer puts it together, does the other person have to have a lawyer look at it for it to be valid? Does that does that count?
You should have a lawyer. And in Massachusetts, it's advisable to make sure you have another attorney look at the prenuptial agreement. If you don't have another attorney look at that prenuptial agreement, person does it at their own peril. If I was drafting that agreement, person decides not to have an attorney, I will make sure that that's in the agreement.
There'll be language.
There will
right?
be language in there so that it will not be
Be waived.
invalidated. That's right.
Right.
That's right.
The contract should say, the prenup should say that the person who chose not to have a lawyer had the right to get a lawyer,
right.
understands they have the right to get the lawyer, and has voluntarily waived that right.
We don't have a lot of time left, although I think there's plenty more that we should discuss, perhaps on the business-to-business side of it. But the idea of indemnity clause, could you briefly talk about what an indemnity clause means and how it pertains
Take a
to a
stab at
contract?
that.
Well, when you say indemnity clause, are you talking about that we have a contract where someone's coming to do something, and if they don't do it, they're going to indemnify that other party and hold them harmless for their actions?
Yes, and how far-reaching is that, and what about negligence? And
Well, here's where you'll see things of that nature. For example, I own a piece of property, and I'm going to enter into a contract with you so that you can use it. We call that a lease. In that lease, there may be language about indemnification. If you're running a store on the property that I own, someone comes in and gets hurt in the store because of some negligence that you did, you're going to indemnify me for any claims. As the owner of the store, I may be liable of the building, but as the person who's leased the property and you have control of it, I want you to, number one, have insurance to protect me, and number two, to indemnify me against any claims that may be brought. That's an example.
it sounds like that's something that someone might not be so aware of, and something that a lawyer certainly would pick up on immediately. And in terms of who the responsible party is in any given case, I'm not sure that the average consumer, when they're entering into contracts, they would understand the extent of who's responsible for what. Is it always true that you have to clarify each person involved in a contract, who all of the players are, and who needs to be responsible for what? Does that need to be absolutely specified?
Oh, yeah. Oh, yeah.
It's his fault? No, it's his.
A well-drafted
You have
contract
to
will
have
include
your
that
parties,
language.
yeah.
And that's something that can be negotiated between the parties.
It sounds like that's something we might want to follow up a little bit more. And business-to-business law certainly has its issues. We've had questions in the past about purchase and sale agreements. We certainly didn't address every issue in this particular session, but I think that it hopefully will help you be better equipped to at least ask the right questions. And most of all, the word that we mostly understand is that you really do need to read, not skim any contracts. We hope that you found that this session was helpful. We invite you, as always, to send your questions by email, or you could always call Full Channel. Jackie Grasso, David Bazar, we thank you. And we seldom say it, but we do want to thank both Jesse Dufel and Jennifer Follett, who have been producing this program for a couple of years now. We never have an occasion to thank them, but we certainly do appreciate it.
From day one.
From day one, they've been doing this. Thank you. Join us as the discussion of legal matters continues.